Hello students, in today's session let us learn about employment of young persons as per Factories Act of 1948. Employment of young persons. A young person has been defined under the Factories Act in section 2 clause D as one who is either a child or an adolescent. According to section 67, a child who has not completed the age of 14 shall not be allowed to work in a factory. For the purpose of determining the age of the child to be employed, the manager cannot depend upon the statement of the applicant child. Grant, revocation and renewal of certificate of fitness. Certificate of fitness is granted by the certifying surgeon after examination of the young person. For examination of such young person, application has to be made either by the young person or by his guardian or by the factory manager, as the case may be. Before granting the certificate, the certifying surgeon shall inspect the place of work and the manufacturing process in which the non-adult worker has to be employed. Working hours of children and weekly holidays. No child shall be permitted to work in a factory for more than 4.5 hours and during the night shift. The period of work for all children employed in a factory shall be restricted to 2 shifts so as to not to overlap more than 5 hours. Frequent change of shift is not permitted. Provision of equal weekly holidays is equally applicable to child workers. No female child shall be allowed to work in any factory except between 8 am and 7 pm. Dangerous operations. The state government may prescribe standards by making rules in respect of employment of workers involving dangerous operations. The occupier may also be required to provide additional welfare amenities and sanitary facilities and the supply of protective equipment and clothing and laying down the standards having regard to the dangerous nature of the manufacturing processes or operations. Notice of accidents. According to section 88 clause 1, it is the duty of the manager of the factory to notify in the prescribed form particulars of accidents with details regarding causes of death, causes for bodily injury on account of which the injured person is prevented from working for a period of 48 hours or more immediately following the accident. Safety and occupational health surveys. Section 91A speaks about safety and occupational health surveys undertaken by the Chief Inspector, the Director General of Factory Advice Service and Labour Institutes, the Director General of Health Services to the Government of India, such other officer as may be authorized in this behalf by the state government or any of the above mentioned authorities. Presumption as to employment. Person found in a factory deemed to be employed therein. If a person is always found inside the factory except for meals or rest, he shall be deemed to be employed in a factory. In order to uphold the presumption, first of all it must be shown that the premises in question is said to be a factory. Onus as to age. Invariably, when a person below a certain age is employed, it is for the employer to prove to the satisfaction of the court that the person has attained the prescribed age for doing the work. In the alternative, he can produce a declaration in writing by a certifying surgeon that the person concerned is an adolescent and he is competent to work as an adult. Hope you understood this session. Any doubts regarding the subject discussed here can be clarified by sending me a mail or making me a mobile call. Thank you.